Welcome to the latest Evershed Sutherland Legal Insights podcast.
Welcome everyone to the latest edition of our Tech Talks series, and I'm very excited about today's subject. We have been covering a lot of the challenges associated with artificial intelligence, generative AI solutions as they are rolled out by organizations across the world. A lot of promise, a lot of excitement about the way AI can increase efficiencies and can make our lives much easier. But there are, of course, legal challenges that arise. We've had various other discussions and podcasts around the IP challenge, the data challenge. But today we want to zero in on the challenges around employment law and labor law in that space. And it's a fascinating set of issues that we're grappling with. And I have with me two great speakers on the subject with a lot of experience and who are dealing day to day with these challenges. I've got Mahon and Stephen Chegwin, both partners in our employment and labor practices in the UK, but both with some global responsibilities in that space, and they'll be able to help us navigate through those various challenges. So welcome, Hannah and Stephen. So if we could start with an overview of some of the employment law issues that AI throws up. There's been a lot of talk about bias and other issues that regulators are grappling with. So Hannah, if I could ask you to set the scene for us, that would be really helpful.
Yeah, sure. No problem, Nasser. So I think the main concern with AI tools is the lack of transparency in how they work. So although AI may be perceived as a neutral tool that can eliminate human bias, it can still result in discrimination reflecting its source training data. And this is because AI systems often learn from historical data, which can contain biases. So if the training data is biased, the AI can perpetuate and even exacerbate those biases, leading to discriminatory outcomes. And also the algorithms themselves can also be biased. And biases may arise, so for example, from the design, the objectives, or the optimization process of the AI system. So for example, if you're training a recruitment algorithm to identify the right candidates, this will mean comparing candidate data with company data and top performer profiles. So if the company's workforce lacks diversity, that lack of diversity will be reflected in the data that's then fed into the model, and the software will reproduce it in the results. Also, AI systems may not treat all individuals fairly, and therefore it will disproportionately impact certain groups. And that can then lead to disparities in, say, for example, access, opportunities, and outcomes. So research has found that facial recognition technology used to assess candidates in video interviews or to monitor attendance at work does not work uniformly for all skin colours, creating risk of discriminatory outcomes. So if we now just think about what form these discrimination risks might take. So regulation of AI in the workplace is unfortunately governed by an existing employment legislation, much of which predates the iPhone and which was not designed to address the rapid pace of the development of AI. That, of course, may change in due course with the new Labour government, and we'll talk more about that later in this podcast. But for the immediate term, we are stuck with the existing employment legislation. So the focus historically has tended to be on a risk of indirect discrimination through AI. And that's where an AI system would apply the same rules to everyone, but the decision or the output has a disproportionate impact on persons with a given protected characteristic. And as yet, there's no English authority on the point. An algorithm and a database could be seen as what we in employment call a PCP, under the meaning of the relevant section of the Equality Act, and therefore it would sort of form the basis for bringing an indirect discrimination claim. And although an employer may be able to show that it had a legitimate aim in using an AI tool, but due to the transparency void, so by that we mean not having the information needed to understand and explain how an algorithm works, it may then struggle to show its actions were a proportionate means of achieving that legitimate aim. And I'm sure most people will have seen in the news, there was an Uber Eats driver who settled discrimination claims relating to AI technology that used facial recognition to allow them to log into their work accounts, and which he claimed generated more inaccurate results when used by Black and minority ethnic workers. But also, it's possible that the reason an AI system makes a particular decision is because it has been trained to take into account a proxy set of criteria that indicate the presence of a protected characteristic, so not the protected characteristic itself. Where that gives rise to less favourable treatment, it could also constitute direct discrimination. And this has been described as an automated version of unconscious human bias. So whilst there may be objective justification defence to an indirect discrimination claim, it won't be available in direct discrimination cases, save in the cases of direct age discrimination. Instead, in this circumstance, the creator or the user would have to show that the reason for the AI system's decision is not because of the individual's protected characteristic, but without a clear understanding of how an algorithm works, that may be quite difficult for them to discharge that burden of proof. So hopefully, Nasser, that gives you a kind of brief overview.
Thank you very much, Hannah. Absolutely. So in this context, I would say the regulatory landscape around AI, varies globally, and there's different approaches, from sort of the approach of a standalone all-comprehensive law, such as you have in the EU AI Act, to other countries that are adopting sort of a principle-based approach. We're seeing different models of regulation around AI. So if we take that and localize it to the employment and labor scene, how do you see that affecting our clients and the day-to-day work that you have as an employment lawyer? Stephen, you want to start with that?
Yeah, sure. Thank you. And I'll take a look at this from a collective point of view. So that's in relation to trade unions. And I'll be looking at it globally and not just locally here in the UK. What we know is that employees and by extension their trade unions are quite concerned about the implementation of artificial intelligence, mainly because there's a fear that this will lead to job losses rather than job creation or job enrichment, and potentially increase stress on individuals as more simple tasks are taken away from them and they're left to focus on the more complex task. So giving them a little respite in the workplace. But despite those collective concerns, what we see globally really is that regulation of artificial intelligence, when it comes to collective voice and allowing workers and trade unions to have a say, whether that be over its implementation or development, is quite variable across the globe. And in some cases, it's not even existent. And if we start at one end of the scale, so in the UAE, in the Middle East, things are unlikely to change as a result of a collective voice. And in many parts, trade unions or labour unions aren't permitted. And any change is more likely to come from government-led regulations, as the desire is to become more fluent with regulating AI and being seen at the forefront of it. If we then move to China, this is a country which is quite advanced when it comes to technology and AI, of course, but there is very little, again, in way of regulation, which allows for a collective voice out there. And whilst trade unions are permitted within China, there's only one authorised union to operate that can operate out there, and they've reported very little in terms of what their strategy is with respect to artificial intelligence, and in fact they might see it as a benefit to their workers. So therefore, arguably, if there were regulations out there, that might have slowed innovation down somewhat, and that might be a reason why there's a lack of collective voice in that respect, because they want the economy to develop and create more jobs and opportunities. Then if we turn to the US, again, the acute lack of regulation out there it is quite clear, and that's demonstrable by the fact that we had high-profile strikes in Hollywood, and one of the reasons for those strikes was the introduction of artificial intelligence to replace writers. So again, this is another country where there's a lack of regulation, a lack of, around collective voice. But here what we saw is that the unions were more prevalent than perhaps other countries, and filled the gap where the regulation was missing. So what they did was obviously put pressure on businesses with their strength in numbers and made them negotiate, because what they were saying was, well, if you don't negotiate with us about introducing technology, you can't produce any more films. So it was particularly helpful, obviously, for the US landscape and for trade unions and workers in the US, that this was in such a high profile industry where big names were affected and were coming out and speaking in favour of regulation and getting this sorted. Whether or not that would have happened, or we would have seen as much pushback and more examination on whether or not we should have a collective voice in these areas remains to be seen if it was in a different industry, for example. Then if we turn to Europe, where we know it tends to be a lot more regulation than some of the other jurisdictions, what we can see there is there are more regulations on technology and collective involvement. So we have the recent AI Act, but in places sometimes what needs to happen is to look at old legislation with a more creative eye and interpret laws and regulations that are in place or which were drafted for another purpose some years ago, in order to apply in situations where they will be introducing a new technology or AI, for example. But for others and for other jurisdictions within Europe, there are clearer pieces of legislation. So, for example, in Germany, they have works councils, which is a body of employee representatives who have a right to be consulted on certain things, and in some cases co-determine certain matters. And there's a specific right in German law to be consulted on working procedures and operations, which includes the use of artificial intelligence. Now, if the AI places a special burden on employees, in those circumstances, the Works Council has the right to potentially veto or control the implementation through co-determination, and therefore can slow down the implementation of AI altogether. Now, if we look over into the UK, so in the UK, there is collective voice, and that's established in law, but where the trade union is recognised in the UK, they have no right to negotiate or be consulted on technology matters such as the introduction of AI or how it's used, unless the employer freely grants that right on a voluntary basis. And that's quite rare, say, for perhaps in public sector organisations or ex-public sector bodies. But even when that right is granted and that's there, and the union's got the right to negotiate these things and therefore block it, there's normally a legal right for the employer to press ahead anyway in certain circumstances. And that's something we've been advising on quite extensively, but it's something where employers must be cautious, because if they do this and get it wrong and push ahead with their plans when they've given a right to negotiate, then it can become very expensive very quickly in terms of bringing lawsuits and paying compensation if they succeed. However, one thing to note in the UK is that where the trade union is recognised, they do have rights to be consulted on health and safety implications. And what we have seen is employers and unions talking very much about the implementation of AI and how that might affect health and safety. And that's because unions do have the right to be consulted on these sorts of issues or AI when it does impact the health and safety of its workers. But they can't block it, which is something which might happen if the right was changed to one where the union is permitted to negotiate. So a bit of a mixed bag globally, but more collective rights in the West and more collective voice in the West than perhaps in the East and the Middle East. But turning back to the UK though, Hannah, the TU have proposed some draft legislation, haven't they? Do you want to take us to that?
Yeah, sure, Stephen. So back in 2023, the TUC, that's the Trade Union Congress, established a task force to draft new legal protections for AI regulation and employment. And in April of this year, it published the Artificial Intelligence Regulation and Employment Rights Bill. And so, although this bill was not a joint project with the Labour Party, Labour has provided general support and participation in the TUC task force. In addition, last year, a Labour Party MP sought to unsuccessfully legislate on AI employment rights via a private member's bill. So sort of, if you take this together, I think it's fair to say with the change in recent government that this suggests a willingness to legislate in this area. And the bill provides some clues, but not blueprints, as to the potential direction of travel. So if we just look at the bill briefly now, it's drafted, they say, to address significant gaps in the existing legal framework. And those gaps are identified as being a lack of transparency, observability, explainability, and of protection against discriminatory algorithms, an imbalance of power over data, and insufficient worker voice and consultation.
Thank you very much, Hannah and Stephen. That's absolutely fascinating. And if I ask you to look into the future or the crystal ball, what do you see happening in the coming period? You mentioned the new Labour government in the UK. In terms of changes, in terms of practical things that may arise in the coming period, what do you foresee in the UK and more generally, and what would you advise employers to keep under review or to prepare themselves?
Yeah, sure, Nasser. So I think if we look firstly at what kind of Labour's plan for changes, if I take the regulatory side of it, and perhaps Stephen could talk to you briefly about the engagement side. So just looking at the regulatory side briefly, I think they'll be looking to ensure that employment rights keep pace with technological change and the use of algorithms. So probably be looking to include a strengthening of discrimination law and the promotion of best practice to safeguard privacy. And there's talk of a new regulatory innovation office, which will help improve existing regulatory processes. Stephen, so from an engagement perspective?
Yeah, sure. What Labour have said is that they really want to put the workers' voice at the heart of the digital transition and ensure workers' representatives are involved in the introduction of remote surveillance, for example.
And then just practically, Nasser, so you picked up on that. So again, looking at the regulatory side of things, I think it's fair to say that employers should anticipate reform and stay updated. So to mitigate AI workplace risks, employers should, I'd say, as an absolute minimum, review AI policies and training, refresh contractual terms, assess employee engagement, review the level of transparency around the use of algorithms. I talked earlier on about the transparency void. And I think lastly, probably audit workforce risks. So that includes both sort of privacy and some of those discrimination and bias risks that I mentioned earlier on. Stephen, from an engagement perspective?
Sure. Labour's proposals really are expected to involve a duty to meaningfully consult with trade unions or elected representatives where there's no trade union on matters such as AI, remote surveillance, and other sorts of automation in the workplace. So a bit of a change from what the UK has seen in the past, and that really reflects the direction of travel in the recent EU legislation, for example, where we've seen it with platform workers, which requires employers to involve workers in the use of AI and algorithmic decision making. And from a more global perspective, though, I think one of the things that employers need to keep in mind is that whether or not there's a union presence, or whether or not whether that be in the company or in the country at all, the fact is that employees are going to be worried about the introduction of AI or technology, and to get the best out of their employees or to keep employees engaged, they really need to be brought on the journey with them. So talking about these things early on and involving employees and their representatives, whether they're on these things, and trying to get them on board and encourage them that's a good thing, will only do well for the business.
Well, Hannah, Stephen, thank you very much. That was a great overview of some of the major challenges around employment and labor laws globally when it comes to AI. You've given us a good flavor of all of these and some of the changes that we can expect in the coming period. Thank you both very much.
Thank you for listening to the Evershed Sutherland Legal Insights podcast.